Hello and good afternoon to all of you. Happy Halloween for those celebrating. Certainly here in New York City, we are, and looking forward to having a terrific uh, afternoon of presentations from bond attorneys for you. We're going to make sure, though, that we keep it fun, we keep it light, and we at the same time give you content that is worth the lunch hour that you're sharing with us. So, if Kathy, you'd go to the next slide, please, I'll walk everyone through the programming. And again, for those of you who are interested in trick-or-treating, that's for later this evening, and we'll just do our best to have some fun along the way. I also want to make sure that all of you appreciate that it's National Cybersecurity Awareness Month. We will have Jessica Copeland among our presenters today to talk with us all about cybersecurity and data privacy and the work that we do here at Bond. And what you see up on the slide there is our agenda for the day. I'll be covering some recent New York State bill signings that are potentially harbingers of things to come. We'll know more soon. Roger Bearden, who's with us from the Albany office, who's been on the program a few times now, will be looking at payment transparency activities through the Medicaid program and also affecting specifically home and community-based services and other relating issues that Roger is looking to weave in. We'll turn to Pete Jones next, who's going to be moving thereafter to workplace speech issues, and there should be plenty to say. We are in a complicated environment right now, of course, with the world being a somewhat turbulent place, and lots of people have opinions. There are ways to do that and share that well. There are ways that may be problematic, and Pete's going to talk about some of the dynamics he's seen in his practice. Jessica Copeland, as I mentioned, is with us from Buffalo. Pete, of course, from Syracuse, where I hear it's snowing, or at least there are flurries. There aren't any down here in New York City. What I'm interested in making sure Jessica is going to be, again, covering Cybersecurity Awareness Month. She leads our cybersecurity and data privacy practice areas, and this is the first time Jessica will be on this program, so we're delighted she can join us. Jared Joyce, also back on the program, a frequent contributor, will be talking about new funding opportunities that have just been noticed under the CHIPS Act. And then I'll wrap things up by around 12:45. But why don't I get started, please, Kathy, on the material that I'm intending to cover. In terms of recent bill signings in New York State, there are trickles, as it were, no pun intended, with the first issue concerning flood insurance, but there are beginnings of more volume of signatures that we're going to be seeing from the governor, we expect, as we move toward the end of the year. None of the big items that many have been waiting on, for the most part, have yet been addressed by the governor, but we're starting to see some movement before year end. And so I mentioned in passing flood insurance disclosures. There is another bill that just became law concerning affirmations and civil actions in lieu of affidavits, which has certainly import for various civil litigation matters. Then you move to the next one, number 3 on the list, which is not-for-profit corporation law. There was essentially a liberalizing of what had become somewhat clunky procedural rules. Stay tuned on that one. We're hopeful to have Delaney Knapp present on a future program concerning that in more detail. And then there are various bills that have passed and that the governor has signed concerning alcohol consumption and sales. You see a graphic to the right-hand side of the slide concerning the governor's announcement on the same. But if you go to the next slide, here's all the stuff we're waiting on. The Clean Slate Act, which we've talked about before, that would have pretty profound effects concerning individuals with justice involvement, felonies and misdemeanors, and the ways in which the backgrounds that they have are sealed, and the timing around that relative to their justice involvement, which would have really interesting implications for the workforce. There's a reparations commission bill that has passed both houses. The Grieving Families Act, we've definitely talked about here on the program more than once. Campaign finance standards, non-compete restrictions that would be profound if ultimately moving forward into law. And then there's a effort to have LLCs have greater transparency. The governor hasn't signed any of these yet. And so we'll be watching to see whether these move over to the governor's desk for consideration and what the governor does. But before we get there, and that'll be on future programming, let's move to our first speaker of the afternoon, because we have plenty to cover, as I alluded. And what I'm excited to do is in a moment turn the floor over to Roger Bearden, who's back with us on the program. As you know, Roger is an attorney who joined Bond earlier this year, senior counsel based in our Albany office. And Roger brings significant experience both as a leader in New York state government and in other settings where he's practiced law, and brings that integrated knowledge to government relations and healthcare. And I asked Roger if he wouldn't mind summarizing some of the activities that we've been seeing recently around home and community-based services. There's a lot of effort to better understand what happens in those service corridors. And so, Roger, please, from here, I'd love to learn more with the audience, and I look forward to sitting along. And I am really glad that you can make it back on the program after a couple weeks. It's good to have you back.
So much, Gabe. And in honor of the holiday, for those of you who can see my video, which I just got shut off somehow, could somebody put my video back on, please? I can do it myself, I guess. So yes, I'm wearing a lab coat in honor of both being part of the healthcare group and Halloween. Unfortunately, my doctor's degree is a Juris Doctor, so I will not be able to prescribe. So the next slide, please. So one of the things that we wanted to highlight here, because it really falls at the intersection of various folks in the healthcare and those in the industry who are, employing healthcare workforce, there's a growing interest in understanding what is happening in government-funded programs when it comes to the healthcare workforce. On the one hand, there's a concern from those who are concerned about the tax impact and the size of the New York State budget in particular when it comes to Medicaid. And then, over many, many years, most of Medicaid payments have moved into so-called capitated arrangements. That's where insurance companies will receive a single sum of money and then be able to negotiate with a variety of providers around the rates of payment. That's often not particularly transparent to either the state at times and at times to various interested stakeholders who might want to know how is that money being distributed, and in particular in light of the ongoing shortages which are throughout the workforce that is providing healthcare in New York State and frankly elsewhere in the country. These shortages need to be understood, and the solution that's being arrived at in both the state and the federal side is greater transparency. If I could go to the next slide, please. So I wanted to highlight an as yet unsigned but passed both houses bill that also has been receiving a fair amount of press attention in the last week or two, which is the home care transparency bill. I'm giving in the slide the assembly number, which is Assembly 1926A. And what that would do would require the Department of Health to publish annual data on the number of individuals receiving home care services, stratified by various criteria, who's paying for it, different types of payors in the state, the number of individuals who have been transferred out of home care services into more institutional care with a nursing home or assisted living, and certain aggregated information about service usage. So next slide, please. So the idea behind this bill is that there would be, an increase of information available to the public. So once again, for those who are advocating around the size of the state's budget, they see this very large increase in home care utilization and see that as a concern. There are also concerns from those who are providing those services in the industry about what's happening. What is the interrelationship between various payors and the actual service providers? And I think part of this can be understood in terms of the larger trends that are happening on a federal level that I wanted to highlight as well for folks. And if we could go to the next slide. So there's a couple of regulations that are going to be, if finally adopted, and we do think they will be adopted early in 2024, that are going to have a pretty significant impact on these industries. First of them is the federal access proposed rule, which was published earlier this year. And what that is doing is requiring that at least 80% of Medicaid payments be go directly towards the personal care, the homemaker, the home health aid services, the direct care workforce, as well as requiring states to publish average hourly rates for those services. The clear intent on the federal side is, and based upon a judgment that there's an overutilization of these funds to support non-direct care, administrative costs, but it will push for transparency and will likely create additional burdens on an already quite regulated industry, because the data that would be necessary would be one that would be collected by the providers. It's also going to have some very interesting, I think, ripple effects for those who, for whom this is proprietary information, for which the information about the wages and the wage scales may be very relevant to in a unionized environment, those entities where competitors that may want to have that information. There's a parallel rule, and I'll go to the next slide, please. It was published, I think, literally on the same day, which would do the same thing with respect to managed care payments, really require the disclosures and public disclosure of that information. So when you read what's happening on a state level, what's happening on a federal level, you're going to be in a position where a lot of things, assuming these go forward, that are currently not well known and not well understood will be publicly available. And really, I think the reason to be flagging that for our clients in those spaces is this will impact the way in which people think about the business decisions they're making moving forward, because the information that might otherwise be held closely will be relatively well known. And if we can go to, I think, which will be my last slide. So as I said, in talking about a couple of them, I think there's going to be some implications for how the healthcare industry in particular moves forward. You also have what's already law, the disclosure of material transactions through Department of Health, a lot more information that is going to be known to all parties when they're contemplating transactions. And then also you have this potential adverse impact when you are trying to impose a new burdens on an industry that's struggling to meet basic needs. You may end up with not expanding access, but actually constricting it. So with that, I will turn it back over to Gabe. Thanks, Gabe.
Thank you so much, Roger. It's really terrific that you could jump on as you did, and to give our viewers a heads up as to what may be coming in this home and community space when we're looking at data transparency and the various implications, including competitive and business ones. Let's shift gears now and bring back an old friend of the program, a former host of the program, Pete Jones, who's with us from Syracuse. Pete is here to discuss difficult workplace speech issues. But before I turn it over to Pete, I just want to remind all of you that Pete is one of the central labor and employment attorneys at our firm based in Syracuse. I had the pleasure of presenting with Pete earlier this month in a different context. It's always fun to work with Pete. I'm so glad that, Pete, you're here, that you can afford some context on what is a complicated and turbulent time to some degree in the workplace, given the complexities of this moment really that we're living through in the world right now. So Pete, I know that you'd put some thought to what might be useful for the group to think about in that context, and I want to give you the opportunity to share your thoughts, please.
Thanks, Gabe. Appreciate it. It's good to be back here. And I would say before we get started that I too have a special costume today. I'm dressed up as a labor and employment law attorney. I thought I'd try that today to see how that works. I didn't realize we were dressing up, or I would have done something a little bit more special. In any event, this is a serious topic. So levity aside, this is a topic that we have discussed periodically and I think more recently as the workplace has become more fraught and frankly, as the outside world has become more fraught. We have had political tensions that are, rising and pretty high, in this country, really preceding COVID and the pandemic. I believe that added to things a little bit. Now we've got obviously a very tense and tragic situation in the Middle East that that has people, very concerned on all sides. And so we really, I think it's time to pull back out our playbook here, our handbook for how we address, speech that affects the workplace. And to set the stage on that, I thought I would start with, that obviously just calling out the two potential areas where we may see this speech. They're both have their complexities. On-duty speech, that is when the employee is in the workplace or at work. Obviously, that can happen on work time. It can happen in a disciplinary meeting, which might implicate some additional issues. It may happen with coworker discussions, which of course could happen on work time or break time or before or after the shift. But I would lump that all into the on-duty category, at least for purposes of trying to catalog things. It can happen via communications that take place at work. And I reference primarily here email, but employees may also text each other, DM each other, and so on and so forth. So, we're looking at, communications that are not necessarily verbal, but occur, through some sort of textual exchange of information. And then, the last thing is, that I just wanted to point out is, things that may be put up in the workplace, or, taglines that employees would put on their emails, or other communications and other forms of speech like that. And, we think about people who put up a little banner from their favorite football team in the workplace, and then then we also have communications that are that relate to potentially other things like people's political positions or matters that are in the news on a daily basis, and we could be getting into areas where people feel very strongly on both sides. We also have off-duty communications. And, generally speaking, those communications are, the employees' off-duty communications on their own time and not of central concern to the employer. However, in this day and age where, we've got social media and people follow each other, and the workplace is sometimes a topic of discussion on social media, or, coworkers who met each other through work are offended by what each other say or concerned about what people are saying via social media. There can be a connection, a nexus to the workplace that implicates employer interests there as well. So those are some of the things that I'm thinking about just by way of an overview. Okay, so I thought I would create a checklist of things to assess. And I really do recommend the checklist approach here when we are involved with issues of this nature, because I think we just want to make sure that we're not missing anything. I mean, this is so you might even turn this into a checklist or create an actual official checklist either, in a Word document or an Excel spreadsheet or piece of paper, if you're so inclined, whatever your favorite method is, but to make sure, or mentally, but to make sure that you go through the concerns whenever we're dealing with these kinds of issues. So, first of all, as we all recall, discrimination and harassment is prohibited under state and federal law, and local ordinance in many cases, on the basis of a number of categories. And I listed some of the most common ones that we would be concerned about in these areas, such as religion, national origin, race, sex, sexual orientation, gender identity. Any legally protected characteristic carries with it the potential for a harassment claim if a hostile environment is created due to conduct that relates to the protected characteristic. And I would just remind people that the standard for a hostile work environment under federal law is severe and pervasive, that you need conduct that is both severe and pervasive. And there's a little bit of an offsetting sliding scale of the more severe it is, the less pervasive it needs to be. And the more pervasive, the less severe it would need to be to create a hostile environment. But it's a very vague line that will depend upon the fact finder, the investigator, in terms of when you cross over the standard of being severe and pervasive. But under New York law and under the New York City Human Rights Ordinance, we have a lower standard, which is anything that exceeds the relatively low standard of petty slights and trivial inconveniences could be considered a hostile environment. And that is, I don't know exactly where the line is on that either. That would depend upon your fact finders and your investigators and the facts of the individual case. But I think we could safely say that it is a somewhat lower standard than severe and pervasive. And so when you've got this workplace speech or conduct that implicates, let's just use an example, religion, and it could, it doesn't take a lot of conduct to potentially trigger concerns about a hostile environment. So you have to be concerned about that. Now, it's also worth noting that a lot of these things have the potential for people to have varying rights on both sides of an issue that's brought to the attention of the employer. People who say this conflicts with my sincerely held religious beliefs, and other people who say, but I'm in a protected category on the basis of, my sex or, gender identity or whatever the case may be. So we could have situations where we have to navigate two employees who are saying, I'm protected under the law because of this characteristic, and then the other person saying, well, I'm protected as well, due to a similar characteristic or a different but equally protected characteristic. So that's what can make this difficult. But that's why I recommend the checklist approach, that if we've got our checklist out, we can assess what the conduct is, whether it's protected conduct or based upon a protected characteristic or not, and then start to make some headway towards addressing it. So the other thing I would note here is First Amendment, and I note it for two reasons. Number one, a lot of people would say, oh, I have First Amendment rights, and we all do, for sure. But your First Amendment rights and employees' First Amendment rights are very different in terms of what you have the right to say versus what the implications of that speech are in the workplace. And so it's a little bit more complex in the public sector, beyond the scope of my presentation today. But in the private sector, even though you may be legally privileged to say certain things, the employer can sometimes react to those things if it implicates the EEO laws, company culture, business interests. And so I think this is a misnomer that we hear about a lot, especially our HR folks. Well, I have I have free speech rights. And, the thing that I think we need to be clear with folks on is, yes, you do. The government's not going to, put you in jail or punish you for protected speech, but that doesn't mean that your speech doesn't have consequences. And I think that's just a little bit of education there. Also on my list of things to keep in mind and assess is National Labor Relations Act protected activity. Employees have the right to engage in protected concerted activity under the National Labor Relations Act. In order to qualify for that protection, it must be both protected and concerted. And there's, legal definitions of both. Again, beyond the scope of our discussion today to get into the details on that, but where employees are commenting on working conditions or the employer, and they're engaged in that commentary in a concerted fashion, that has to be on your list of things to consider to make sure that if you're going to react to that conduct or prohibit or take discipline based upon that kind of commentary, you'll want to make sure that you're able to do that under the National Labor Relations Act. I also think we want to look at employee handbooks. What are our rules in there? Both rules that afford employees, certain rights and privileges, but also those that might implicate, statements that they make that are offensive to other employees or that are discriminatory. Social media policies would be another thing to take a look at and assess what we've said. And if it's, frankly, from a proactive standpoint, if it's not well worded today, we may want to get on that and change that before we get into a situation where we got a handbook that doesn't fit our needs. I will flag academic freedom as a concept that is very much applicable to our higher education friends. Briefly stated, it is a concept in higher ed which is designed to protect the teaching and the scholarship and the research that relates to ideas. And the notion is that people, in order to pursue the truth and advance the learning and the education that goes on, viewpoints need to be protected, and people need to be free to say certain things and write certain things and explore controversial topics. And this is also a complicated topic because there are borders, there are limits to academic freedom. I think maybe we'll perhaps devote another session to this, maybe next Tuesday or after that, to delve into some of the higher education nuances here, including those that would involve students and faculty. But just flag that if you're in that context, because that's another thing that you have to navigate. And then we've also got political viewpoint. In New York State, you've got New York State Labor Law Section 201D. It protects lawful off-duty conduct, and among the things that are protected there are political activity and certain, political statements. That's primarily something that you would need to be concerned with respect to off-duty conduct. It also protects lawful recreational activities that employees may be engaged in. And so just let's put that on our list of things to be thinking about, especially if we're talking about social media or off-duty conduct statements and things of that nature. So just to highlight some of the difficult issues, and I think I got to move it along here because I want to make sure I save enough time for Jessica. But we've got and Jared. So we've got employee misconduct that could happen in disciplinary meetings. It's possible that some of that conduct could venture into protected concerted activity. We've got politically charged positions that somebody might take on social media. Again, your lawful off-duty conduct, you've got, some protections there. But will it impact the employer? Is there a nexus to the employer? As I mentioned before, someone who says, certain things can conflict with a protection I have. Let's just say they conflict with my religious beliefs, but on the other hand, a person is protected due to another characteristic that they have. We see a lot these days about with bullying activity and people who say this is not a safe work environment. It's a problem for me. And so there's a lot here to be concerned about. let me just leave you with a couple of practical tips. Thank you for spending a few minutes on this topic with me today. But I think you should look at your policies and your handbooks, and I think you should examine your practices, especially your practices where today you're letting people post things or put things in their emails, or you're tolerating things that tomorrow you may want to regulate. You may want to say, geez, that doesn't really belong in our business communications. We really need to be proactive about that and consistent about that. Because if we're not, now you're into this situation where you're only reacting to certain content, and that could get you into discrimination claims and other concerns. And the last practical tip I would mention here is, I think encouraging respect for the positions and feelings of others. I don't think that's just a platitude. I think to the extent that we can say, and it resonates with folks, look, let's not make other people uncomfortable. Maybe we say a little bit less, maybe we be a little less overt about it, and everyone will feel a little bit better when they're here in our workplace. That's not, I don't believe, asking people to change their beliefs. It's asking them to, in some sense, moderate how overt they are about them when they're in the workplace, and I think that can be a helpful step. Okay, I've said a lot here. I'm going to turn it back to Gabe, and thanks everyone. Good to see everyone.
Thank you so much, Pete. And costume or not, we really enjoyed what you had to share here on a complicated set of topics for sure. And let me turn to Jessica, who is with us from our Buffalo office. Jessica leads our cybersecurity and data privacy practice. And Jessica has been on lots of programs for the firm, but not on this one as yet. And so this is Jessica's debut. We're so grateful, Jessica, that you're making this time. And Jessica, from her vantage point leading the practice group, was interested in talking with us about cybersecurity and data privacy as we wind down the month where we're all thinking about it. But it doesn't mean that what we have to pay attention to is over. So Jessica, please, what are the highlights? What are the important topics that we all should be making sure we keep in mind as we move deeper into 23 and beyond?
Thank you, Gabe, for having me. And thank you for always putting together such a fantastic weekly webinar. Really appreciate your commitment to this. So while this is the first time I'm appearing, I assure you it will not be the last. Thank you for hearing me out. And I would be remiss to identify that I do not necessarily have a recognizable costume, but in a conversation I had with my daughter last week, she advised that I should be Elle Woods, Legally Blonde, for Halloween, since she recently saw it. She's 12. And to which I responded, I'm legally blonde every day. So I somehow survive in costume all the time. But you're not here to hear about that. So let's talk about Cybersecurity Awareness Month. Next slide. I thought it would be good to have a recap of the fundamentals. For those on the call today that have been following us on social media and heard our Bond podcasts or information memos that are issued, if you've read them, I'm sure you've picked up on a couple of common themes. And when we talk about cybersecurity, there are certain baseline protections that every organization, obviously the regulated industries understand this, but some not regulated industries may still be becoming aware of what they need to put into place to protect their information. And we're not just talking about your company confidential information. It's your employee personal information, client information, and customer information. So a real easy baseline is multi-factor authentication. Again, if you've been at any of my presentations over the last couple of years, you've heard me say MFA, MFA, MFA. It needs to be in place. We are at a point in time where there is such a significant uptick in credential compromises, meaning someone's login, username and password. And once that information is harvested by cyber criminals, if you don't have that second layer of authentication to confirm that the user that's accessing confidential information of a company is the legitimate person that's going onto an email account or a system network, then you've already given the keys to the kingdom away without knowing it. So it's a real easy way to put a stop to a credential harvested cyber attack. Another technical measure that should be in place is threat monitoring. There are numerous vendors that provide 365, 24/7 monitoring of your computer network to understand where access points are occurring and to identify anomalies. So if the monitoring company that protects Bond notices that Jay Copeland is trying to access her email from Tunisia, and Jay Copeland did not have planned work travel to Tunisia, then it would identify an anomaly, and then a follow-up email would go through to the IT department to see, okay, is this user traveling for work, traveling for leisure, or not traveling at all, and shut down that access point. So that's just a really simple example of what we mean by threat monitoring. Again, I talk about this often, and it's similar to Pete's World, although very different training sessions. You need to train your employees to have the right cybersecurity mindset. And in doing so, I put phishing as an example because that's an easy way to fall prey to a cyber criminal. There was a one share drive email that went around that was harvesting credentials, not a legitimate email, a phishing email. And what that does is it looks like a legitimate business email, and a user just in the normal course of the business day sees that a client is sending a file that they need to review ASAP. They click on the link asks for a username and password. Of course, the person that receives the email thinks it's the O365 email account username and password that need to be put into this link so that they can access the document. They put it in and boom, your credentials are stolen. So it's really important to train your employees to identify and recognize the phishing-like emails. Also important to train on phone calls that have become the new norm for phishing. So the MGM Caesars cybersecurity breach that occurred a few months ago resulted from a bombardment of phone calls to users on the MGM system saying that they were an IT manager and needed to reset passwords for protection. And of course, the person that received the email, or people that received the email, trusted the phone call, and I'm sure it was masked by a number that looked to be legitimate. And they ended up providing an email and password, and then prompting the multi-factor authentication that was then approved by the person on the phone. So that's a new wave of phishing-like attack that you should be training your work staff on. And then I'd be remiss without speaking about cybersecurity insurance coverage. So it's important, why not a National Cybersecurity Awareness Month, to take the time to evaluate whether you have cyber insurance coverage, if the coverage is enough for the size business you are, and the type of data you're processing. So often we have some smaller companies that are highly tech focused companies. They process significant volumes of customer data, and they might just be, a 3 to 5 employee shop thinking they don't have an obligation to have robust cybersecurity insurance or practices. But that's not the case, because the value is in the data that you hold. So your insurance coverage should encompass what your risk factor would be. Next slide. So where should you begin? Well, I always say that you should start with a risk assessment. It's just like going to your doctor for an annual physical. You don't know where you need to maybe cut back on sugar or cholesterol until you see your blood panel, right? Well, a technical risk assessment does the same thing. It looks at what are the open ports on your network. Where are where are your vendors protecting your information, and who is able to access certain really sensitive files of employees. That risk assessment should be performed on an annual basis, and it should be performed by an outside vendor, because it's not always easy to recognize internal vulnerabilities when you're living in that environment on a day-to-day basis. You should also understand the type of data that your organization processes. Are you a B2B where you don't really have personal information of individual end users? How many employees do you have? And do you rely on third-party vendors for certain support, such as payroll and HR solutions? It is absolutely critical that you have an incident response plan. We work with clients regularly on helping to develop what that incident response plan should look like and practice it. It's not enough to just draft an incident response plan that identifies who to call in the event of a data incident or event. You have to actually have what's called a tabletop to make sure that the if what then statements in the incident response plan are effective, and that you can try to isolate an incident, protect the information that may be impacted, and have certain data backups for redundancy. And then lastly, vendor management. Most cybersecurity or data privacy protection laws require owners of data to make sure that their vendors that are processing sensitive information are adhering to the same cybersecurity standards and mandates that the owner does. So it's not enough to say, well, I paid this payroll processor to make sure that each of my employees receive their paycheck, every other week. And of course they had their social security numbers and bank account information, but their breach is their problem. No, that's not the case. You need to make sure that when you contract with a vendor, you have very clear delineation of who's responsible in the event of a data breach, and make sure that through indemnification, they're protecting your employee or your customer information. Next slide. And then I've spoken a lot and written a lot on the New York Shield Act. So that is New York's law that not only provides what to do in the event of a breach. When we talk about if there's a breach, you need to notify affected individuals. But more importantly, and quite unique to this law, is that there's an actual cybersecurity mandate that requires strict adherence to administrative, physical, and technical safeguards that need to be implemented in any organization that handles electronic data of New York residents. And it's there, while there is a small business carve out, it's not an exclusion. So if you're a small business where you have fewer than 50 employees, then you don't have to meet necessarily the rigid requirements that are identified, but you do have to implement what is reasonable for your organization given the type of data it processes. And I wanted to raise this because there are a couple of information memos this month that speak to recent enforcement actions by the Attorney General's office in New York. And what's important there is not only can the Attorney General levy fines against organizations that haven't implemented the proper safeguards, such as multi-factor authentication, threat monitoring, destruction of information that you no longer need for a business purpose. There's also a significant cost to these organizations to improve their cybersecurity practices to meet those standards. Next slide. All right, well, although not germane to cybersecurity, I am the tech lawyer. So when the AI executive order issued yesterday, Gabe asked if I would just speak to it briefly on this webinar. So I'm sure many of you are aware that the president signed an executive order that identifies how the US government is going to start to regulate AI tools. So there's an executive order that builds upon an initial AI Bill of Rights, and it's seeking to balance the interests of national security and consumer rights as more and more organizations are relying on this tool. It establishes a national AI research resource, and it'll be used to research healthcare and climate change. It regulates AI to ensure that it is a trustworthy and reliable source. So we could have several seminars on AI alone, and Gabe, I offer to you to speak, very strategically through the remainder of the year, if you'd like, on these webinars, because it is such an important conversation to have. And I know I'm running out of time, and I don't want to run over Jared's time. So with that, just know that the order will apply to all companies with powerful AI technologies, regardless of whether the company contracts with the federal government. So this is not just for government contractors. This is any company that utilizes these AI or builds the AI technology. Gabe, would you like to pivot?
That would be terrific. Jessica, thank you so much. Looking forward to having you back for those strategic presentations on AI. This has been truly informative. And let's turn to our last speaker of the day, and we ask the audience to stay with us for just a moment more. Jared has an important update to share with all of you, and it concerns the CHIPS Act. Jared has been here before to discuss CHIPS Act developments, and we've got a new one. So Jared, please catch us up.
Thanks, Gabe, and good afternoon, everybody. So to start off, as a little bit of background, the CHIPS and Science Act of 2022 provided $52.7 billion in funding for the domestic semiconductor industry, and of that, $39 billion is meant to be used for various semiconductor initiatives. Next slide, please. The first notice was issued in February, and excuse me 1 second. And that notice was aimed at the expansion or modernization of commercial facilities for the fabrication of leading edge, current generation, and mature node semiconductors. And then it was revised in June for supply chain projects that exceed $300 million. Next slide, please. So the latest notice was issued at the end of September, and this one is open to projects for the construction, expansion, or modernization of commercial facilities for semiconductor materials and manufacturing equipment for which the capital investment falls below $300 million. Next slide, please. So preferred applicants, preferred is my term, not specifically used in the notice, but those would be projects with capital investments of 20 million or more, and applications by consortiums that advance semiconductor clusters by closing critical gaps in the US supply chain. And the notice provides this very specific definition of what is a cluster. And as I said, it's preferred is my words, but the notice states that smaller projects are encouraged to apply, but they are unlikely to have the scale needed to contribute to the program objectives and may not be chosen if they fall below that $20 million threshold. And that although consortiums are strongly encouraged for cluster-focused applications, the Department of Commerce still intends to support standalone projects. They're able to demonstrate their ability to meaningfully strengthen supply chain resilience, advance US technology leadership in semiconductor materials and manufacturing equipment, and support semiconductor clusters. Next slide, please. So the application procedure, phase 1, interested applicants are asked to submit a concept plan between December 1st and February 1st. The concept plan should outline how the applicant's proposed project will address the core program priorities such as economic and national security objectives, commercial viability, financial strength, project technical feasibility and readiness, and workforce and community investment. Phase 2, the Department of Commerce is going to reach out to the most promising applicants and provide them with more information to allow them to submit a full application. And the Department of Commerce estimates that most of the funding awards will be equal to 10% of the project capital expenditure, but it may be 20 to 30% for compelling cases. Next slide, please. So they do expect to issue one more notice in the near future. That one will address funding opportunities for research and development facilities. Thank you.
So with that, folks, it is 12:50 on the East Coast, and we know that you've stuck with us a few minutes longer. I very much appreciate that personally, as do all the attorneys who presented. If you need to reach any of us, our contact information is there on the slide before you. I will be back with you in November amazingly, tomorrow is November 1st. But before that, you'll be with Kristen Smith on November 7th for the next broadcast. As always, if you have topics you wish to suggest for our coverage, reach out to us. We're grateful for your loyalty to the program. We're very much encouraged by the viewership that we continue to see. Please keep coming, and we're just in service to all of you, working toward making this program as useful as it can be. And in the meanwhile, wishing you a very safe and happy Halloween, particularly those of you with kids and others whom you'll be navigating to trick-or-treating. And we'll see you in November. Be well.